much. forget that I've lived and done this type of work for nearly 30 years. And so much of it, the basics and fundamentals and foundation, it's second nature to me. And I forget sometimes that while I think I'm explaining something, I needed to go one layer further down or two layers further down to explain to people why I say that. So I'm going to start off by just the basics about what you do as a Board of Zoning Appeals. You basically interpret the land use regulation for the city of Shelbyville. And that's a term of what we talk about, land use regulation. And that could mean, it's pretty broad. It not only talks about zoning, but also what we do with subdivisions, how we apply subdivision law. Subdivision law doesn't come underneath y'all's jurisdiction, that's the Planning Commission, but the broad category of land use regulation is what you all do. So, as you all know, we have a constitutional right to our property here in this country under the United States Constitution. It can't be taken by the government without some type of compensation. So a lot of people have wondered, have asked me before, how can you have land use regulation? Because you're limiting what somebody can do with their land. That is fairly well settled law in the United States. It's a very famous case called Euclid. The United States Supreme Court finally came down and said it is a proper and appropriate use of the police power of a government, whether it be, and it's usually at the local level, as well as a state can do it as well, that you can place restrictions on the use of land. And that's what zoning is, a restriction on the use of land. I think we can all agree. We don't want our cities to be structured where you can have a house and then you can have a industrial plant and then you have a commercial business. Everyone, I think, pretty much agrees, except maybe those sovereign citizens that like to live out west and say nobody has a right to do anything except them, that we want designated districts. We want most of your residential to be together. We want your businesses districts to be together. We want your industrial to be together. So that's the basic land use law, and it's been well settled. And so when I talk about being well settled, most of the states have a scheme, I call a scheme or a structure about how land use regulation is done. And so there have been challenges all at the end of last century and the beginning of this century to those types of schemes, and they've been, for the most part, upheld. So that's pretty settled law for us. As I was just telling you a while ago, there's always a risk that something that a legislative body does would be challenged by the Constitution, that someone said, you've gone too far, that violates the Constitution. So let me back up again to make certain, when I'm talking about basic law, you all know Constitution's at the top. Then you've got what your legislative body is your elected officials, whether that be Congress, whether that be the Tennessee State General Assembly, or whether they're that City of Shelbyville City Council. Those people are elected and they can make your statutory law. We've got the United States Code, we've got the Tennessee Code, and we've got the Shelbyville Municipal Code. That's what your legislative law is. And so this zoning resolution is legislative law. So anything that is ever passed could potentially be challenged in a court of law for whether it passes constitutional muster. I guess what I'm attempting to say is most typical zoning schemes that you find in whatever state, in any city, have probably passed that muster over years. Kind of well settled law. Doesn't mean that it can't be. I'm not saying that a city couldn't go so far in passing a new law. If you wanted to be unreasonable, if your setbacks were so unreasonable that left very little that you could do on property, we might get a challenge, a taking challenge. And so that's probably what it would be. It would be a takings challenge under the United States Constitution, as well as the Tennessee Constitution, because you now have basically rendered somebody's property of such less value that you have taken something from them, and they have to have some sort of compensation. So I generally am not worried when we're talking about zoning about the constitutional issues applying our zoning law. I'm usually not worried about that. The other thing that we also have to keep in mind is that also shapes what we do in terms of applying land use regulation and law to the facts that presented us is case law. When the courts make case law, that's your courts are basically applying a set of facts to the law that the legislative body made, so your code. And so sometimes you look at a code, you look here and you're like, I'm not exactly sure what they meant when they passed that. That's kind of what a court does. So you are reading what the actual statute says as well, and that's really where I come in. Do I know what the case law is on all that? The other level that you have in terms of law, your constitution, your code, are regulations. We don't really have regulations at the local level. Your state does, the federal government does. Really don't have a lot of that in land use per se. You all, I could say, have a regulation more in procedure in that you have bylaws. Your bylaws would be considered a set of rules that you all apply to really more how you run your meetings more than the actual law itself. So that's just a general basic overview of what in land use law. So for you all as a BZA, I want you to know you're not just a body created by the city of Shelbyville. The state mandates that when you have land use regulation. So the city of Shelbyville, I want to say, enacted its zoning regulation for the first time in the 60s. I can't remember what year it is. And as a part of that, the state of Tennessee is, that's fine. You are clear to regulate land within certain boundaries in your city limits. But you really need to have two things. You need to have a planning commission that regulates the subdivision of land when you're taking a large tract, you want to subdivide it and make roads and make houses or whatever you want to do. As well as you need a board that oversees certain parts of your zoning ordinance. That is what you all do. So there's an actual state statute that mandates that. It sort of gives guidelines for how many people can be on it, what your terms are, and so forth. So that's how the city sets you up. The main things that you do, as outlined in state law, and we put it in our municipal code as well, three main things that you oversee. Number one, you serve as an appellate body to whoever enforces our zoning ordinance. So, Tom's position as planning director, he in his everyday job is often giving advice or making, I don't want to say rulings, but telling people, I think you fall in here, you don't fall in there. He's giving advice to folks. If someone disagrees with his interpretation and the application of this zoning law to a set of facts for those people, just for instance, if somebody comes in and says, Tom, I need a zoning compliance letter. A zoning compliance letter that a lot of people ask for them is they say, hey, I own this piece of property, here's the location. I need you to tell me what the zoning district is, and these are the things I can do in that district. Or somebody brings him a specific use and says, this is what I want to do. You telling me I can do that here. If he refuses to give that, saying, I don't think you can, somebody can appeal that decision to you all. You have the power to overturn that. Look at the zoning law and say, I don't think that's what that means. And so that's number one, the appellate authority that you have. Number two is a variance. A variance is an application that a landowner can come in and say, I own this particular piece of property and it has something odd or unusual about it. If you apply whatever zoning regulation that exists to my land, I can't meet that. because there's something particular about my land. And there are standards written in our zoning ordinance that tells you what all you have to look at. So that's what a variance is. It's usually, I like to think of it as a hardship. Somebody, literally because of the nature of the land itself, not because they've created something and don't want to do something. It's the nature of what they find on the ground on their land. They can't actually meet it, whereas everybody else can. And we have that, I guess, one of probably the best example, and Tom, jump in anytime if you think you've got an example that would help illustrate what I'm talking about. You sometimes have old lots in this city that are old, and they simply can't be built on with today's regulations because they're so small, or the way that they were crafted, per se. So that is one of the situations. And then I've also seen situations where it's simply the topography of land. Because there's something odd about a hill or something else.
Yeah, there was a project I worked on in Fayetteville where it was split zone. Not that they were doing anything that required BZA, but one of the topography, it was a
Yep.
cliff, and that's how they
Yes.
determined the line of the zoning was a cliff. It was a
Yeah.
natural feature.
I have seen that several times, that it is a natural feature of that particular property that has caused an issue. I've seen that several times. So that is a variance, and there's a specific place we will refer you to in our zoning ordinance, how you need to flip here. And Tom does, you all that have been here on before know very well, he walks you through. I haven't analyzed this application, I've looked at this property. Here are all the factors that we need to consider about whether you do a variance or not. So that's number 2, is the variance. The last one is a special exception. Special variances deal more with bulk regulations. Let me back up, make sure. When I'm talking about land use regulations, you're not only talking about in this district, you can only have commercial. It's also what we call bulk regulations. We have setbacks. You can't build your building so close to the road. We have parking requirements. Those things also are in our zoning ordinance. So variances generally tend to deal with bulk regulations. You do not give a variance for the use of the land. Generally, you don't do that. It's usually bulk regulations. Special exception is a matter of the use of a property. And it's built in your zoning ordinance. So your city council has determined that in A1 districts, all these type of uses are permitted as a right. They don't have to do anything in particular. They have a right. If it's zoned A1, they can do this list of things. Special exceptions are uses that were like, okay, we think they would be okay, and in this district, however, we think those people need to come in, need to apply, and need to show us that they meet certain standards. And then we will give them permission to do that use in that district. So it is really, it's an oversight of a particular type of use. You have quite a few of that, and I mean, you have them in all the districts. Usually, your home-based businesses are special exceptions. Are they all special exceptions in ours?
No, in ours, home-based occupation, there's classifications of type of use that you can do within those. Anything else, there's also those that are just not permitted at all.
Sure.
And usually, or what I've seen in ours, and I've seen it in other jurisdictions, they're just called conditional uses, and they're
The same thing.
Yeah, they're the
Conditional
same
uses
thing.
or special exception.
Yeah,
It's the same term in the law.
yeah. Think of dogs. Dogs are what?
Say them, don't read.
Kennels. And usually it has
That
to
is
do.
one, yeah.
Yeah, it usually has to do with a set of adverse impacts like noise, traffic generation, smells, especially. It could be any number of those things that use creates more of like the dogs creates more smells if you add a lot of uh, sounds as well. Potential getting loose, things like that.
Tom's brought up a good point. The uses that are special exceptions are generally seen as having a greater impact on the land. Therefore, you want more oversight by the city. They're not permitted as of right in that particular district. Now, let me say, there are certain types of uses of land that are permitted as right, as a right. You automatically, if your property is zoned, let me just say C2, you automatically can do that. But in a C1, you may have to get a special exception. There's different ways. That's up to the city how they set that up. So
if you look actually in the book towards the back of the first section, it's Appendix 1,
yes,
and it lists a bunch of different deals, and it shows, in X's, it's right there, like, for example, I can build a single family attached home in zones R1, R2, and R3, but I have to have a special exception for a bed and breakfast in those zones.
Where am I looking, gal?
if you go to the very, very end of your zoning,
The very first section, well, no, in that first tab, towards the end of it, it's
Okay.
let me see if I can help you find it.
Yes, please.
It's
Usually it's
yes,
gonna be in there
it is.
high.
Where'd you put it?
Have to be,
Towards the front.
you keep your.
Where did
on
they
your
put it?
cell, Update the.
Yes, that's-
Okay,
Because we have
it's
to.
in the back of
update
mine.
that several
This right here,
edits As well as the zoning ordinance.
and Betsy, you've not seen this before. This is our table of uses. I'm trying really hard to make Bedford County make one of those. They don't have theirs set up
Thank
that
you.
way.
I'm trying to do I'm trying to do it instead of X's and blanks, either not permitted, permitted.
Yeah.
Special.
planning commission and the council adopts. And it's supposed to be, here's how we see growth happening in the city over a certain amount of time. And we would anticipate that maybe industrial keeps going there. It's not all industrial now, but it may go that way, or commercial's going to continue to go this way. So that is a study that we do, and we update that map ever so often. And it changes. It doesn't necessarily stay the same. That is not regulatory. It doesn't mean that we have to do exactly what that document. And when I say we, I mean the city council in making its rezoning decisions. It doesn't necessarily have to follow it. It's a good practice to know where you want to go, and where growth in various sections are going to go. But that's what she's asking about.
Okay.
So that you'll know there's a comprehensive plan. Ours is called 2040.
Yes, 2040 comprehensive plan, Spark Shelbyville.
When was the last time that was updated?
3 years ago now, 2 years ago.
2022, I think, is when it was
Yeah.
adopted.
Yeah,
It's online.
it is online. Yes, it is online. Most of our documents like this are online.
Okay.
So, again, three main things that you all do. Do you have any questions about any of those particular, whether it be an appeal, whether it be a variance, whether it be a special exception?
How is it determined if there is a business that doesn't fit into these categories?
And we've had that before. We have had that before, and it's usually been a consultation with, normally the director will come running and say, I've got an issue.
Yeah.
Somebody's brought up a use that we don't have, and we often look at it and say, okay, can we go back? Let's look at what our ordinance say. Is there any way that we could justified, make a reasonable argument that it falls into something that already exists? Or do we need to right now go amend our zoning ordinance to create a new use? And we've done that
Well,
on
I
several
was thinking,
occasions.
we have something that may come up with New Destiny, or not New Destiny, but, the cat rescue, but New Destiny would have been the same thing,
New Destiny, what is New
the
Destiny?
dog rescue.
Dog rescue.
Oh,
Does that classify, like, my question would be, is that a kennel? Or is that, which has special exception rules, or is it more along the lines with, say, a pet store? Because I could walk in and walk out with a pet, but they also stay there potentially long term.
Let's probably take a good hard look at that. This is, let me back up. There's something else that you could do in line of an appeal. I just now thought of this. Because we've done this at the city once or twice in the time that I've been here. There have been a couple of times, not with Tom, but with another director, where the director, it's vague. We're not sure. And that was one of them. Not sure if we've got a proper place to put this. And so we have had directors, and the rest of staff have all agreed this is probably the best thing. Let's take it to the BZA for their opinion on interpreting the zoning ordinance. So that could be a possibility, is that we come to you all and say, we'd like you to interpret whether you think this particular use would go here or go here or go here. If it's that unclear, I feel like it's my responsibility to tell my city council they have a duty to get this document up to speed, what it needs to be, instead of putting that burden on you. It would just depend on the facts that are presented to us.
yeah, it has a lot of our appendix and table of uses is, I would say it's broad in its category, but I could see where a kennel might not necessarily apply to a, like I don't know, like somebody that's just selling dogs, or pets. But on the other hand, the default that I always fall back to is, if, you could say that it's not a kennel, but it has kennel-like qualities. So a lot of times what I'll do is I'll research what other jurisdictions do, or I may contact MTS, our technical advisory service, or other planners if they've come up with them. I had, one that came up in 2023, a pet crematory.
Yes, I remember that.
So,
That was a new one for us.
yes, but a crematorium,
Following the principle.
yeah, well, crematorium is generalized in there, and it doesn't describe, or it just doesn't necessarily, I don't think, distinguish between whether that's a person,
Right.
or a pet, because it's the same, it's biological materials that's being, burned and turned to ash. So in that case, crematoriums are in the C2 district. And what's surprising to me is that actually there's no special exception requirement, it's just in C2. So, in that case, a pet crematorium could be
Go
applied
in
the
C2.
same way.
You all currently, and of course I encourage you, and maybe I should walk you through, don't, as you look at your municipal zoning ordinance and you see it's broken down into different articles, don't sleep on Article 1, where you talk about your general authority, your purpose, your applicability. Sometimes the cases that I've actually had go to court have turned on me arguing about the general need for it under general application. So I encourage you to go read those sections if you've not. You'll see that this is kind of where we set out the Planning Commission and the Historic Zoning Commission. We also have you all as a BZA, but we have y'all down in Article 7. Article 7 is all about the BZA, and you will see you've got specific sections on your purpose, your authority, variances, special exceptions, and then specific special exception requirements. So certain things that would come forward, that's where we've got all that laid out when you're doing those things. But Article 2 definitions, it's always important to go back and read what the definition of something is. And I want to encourage you all, y'all are not active in the legislative process at the city. You are the judges that apply the law after it's been made to a certain set of facts. That's what y'all do. You're basically a judge. Somebody's coming forward and say, here are my facts. And you look at the law, which is your zoning ordinance, and see if it applies. I don't want you to think, however, that you're not valuable to the city on giving us feedback as you've done this job and say, you know what? I personally think it would be better if the zoning ordinance read this. Because, and I'll tell you that because while the Planning Commission does see all proposed amendments to the zoning ordinance, they're not deep in the zoning ordinance like you are. They spend much more of their time in a separate document called the subdivision regulations. Most of what they do on a monthly basis is applying subdivision regulations to large tracts of land where people want to come in and make residential subdivisions. And so while they do see whatever that comes up and they'll study it, I don't want you all to think because you're actually not in the process. We don't bring an amendment to this document to you. That's not how the statute's set up. It goes to Planning Commission. It's required by state law that the Planning Commission sees and makes some type of a recommendation or a report on every change to the zoning ordinance. Not the BZA, Planning Commission does it. But I want to encourage you, don't be afraid to say, hey, this is an issue that I think we've got, and I just feel like we need to address it. I want council to know it. I want the Planning Commission to know it. I don't have any problem whatsoever if you all feel like even voting one time and say, we're going to make a recommendation. It's a formal recommendation from this board. We'd like to pass it through Tom, pass it on to the Planning Commission and to the council. We think y'all need to study this. We think this needs to be changed. There's nothing that says you can't do it. You're not prohibited from doing that, even though it's not mandated. It really comes out of the Planning Commission. We know we have to start with the Planning Commission.
Did
Go
you
ahead.
say this earlier and I missed it, or am I just remembering something else? If someone disagrees with a decision from the planning commission, doesn't that also come here for an appeal?
No, I'm glad you brought that up. Let me back up and say this too. Your decisions in the city of Shelbyville are final. It means there is no appeal to the city council. That is how it's set up in state law. Now, let me tell you, it's flexible enough in state law that if a government wanted to create an appeal process, they could. And I use Knoxville has got this elaborate appeal process where it seems like everything can be appealed. But under state law, our Tennessee state scheme, it ends with you, which means that if somebody wants to challenge your decision, they disagree, say you don't give them the special exception they want, and they think they qualify, they then have 60 days from the final decision that you make to run into a court of law and challenge your decision. Has to be a lawsuit. It doesn't go to the city council. That's why I tell people how important it is and our volunteers on these boards, because they're making law and making decisions for people, for their property. It's important what you do. It's very important what you do. And so, and how I have advised my clients throughout the years, and which is why I insist, and I know people don't like it when I do, I always insist that the BZA meet the very next month after you have made a decision on an application for the purpose of approving the minutes, because that starts the 60-day clock. Now, there's some case law that says after a secretary signs minutes, but we don't do that. I've had some other jurisdictions that do that. We don't. We bring those minutes back to you a month later. And so you are like a lot of other places. There's places that their BZA might not even meet in a year because there's no application. And so I've had that before where people have just forgot about the necessity of creating a clock and getting that 60-day, because that is state law. They only have 60 days to challenge. Whereas in some things, like doing something with the planning commission, you got more time. So that's why I always say, I know you have no applications, but you're meeting just to approve the minutes. Because we always need to send our applicants, as soon as those minutes are signed, approved and signed, they need to be sent to that applicant that proves this is what you got.
So
And their clock's running, they got 60 days.
So let's go back to, let me find a good special exception. Let's do the bed and breakfast special exception. So my neighbor, and I think I'm R2 zone, comes in and wants to do a bed and breakfast. And the BZA grants them a special exception.
Mhm.
But I don't think that meets.
Sure.
Is that final? Does council grant it, or can I then, as someone in that area, bring suit against?
If you were living, if you were living next door, I believe a court of law would find that's called standing, that you'd have standing to bring the lawsuit. You probably would. Somebody that's living over 3 miles away, I'm not sure, not necessarily saying the court would. It's a special type of lawsuit. It's called a writ of certiorari for a BZA decision. A writ of certiorari. And what it
I
means
was wondering
is
how you pronounce that word.
certiorari, but now that may be the southern way of saying it. They run into, and here, we have generally, since I've been in, and I know for Bedford County's law too, most folks take it to Chancery Court. On occasion, I've had one in circuit, but usually it goes to Chancery Court. They go and get a special writ, and what they're saying is, we believe that there was an error made by the Board of Zoning Appeals. And so we'll get served, the city will get served with that writ and an order from the court that says you have 30 days, send us your entire record. And you're going to hear me say record all the time. Part of I see my job here all the time when you are doing applications, whether it's an appeal, whether it's a special exception, whether it's a variance, that your record is good. What that means is you are sitting here mainly as a judge. You are technically not supposed to think, talk, do anything about this, but here at this table. Now, you can obviously look at the documents we send you in advance, but you're not even supposed to talk to each other outside. Somebody walks up to you on the street and says, I want to talk to you about this application. You need to blame me and say, the city attorney will be mad at me and will get on to me. If you want to talk about this, you need to come to the meeting. You need to come to the meeting and ask to speak. Let me say this. The general public has no legal right to stand up and talk about somebody else's application. They really don't. Now, having said that, the law changed in Tennessee a year and a half, going on 2 years ago now. In all of our open meetings, not just council, but our beer board, our planning commission, our BZA, we are technically have to have a public comment period at the beginning of all of our meetings, even y'all. So when y'all have a public comment meeting, and if something's on the agenda, technically anybody in the public can stand up and say, I'm against it or not against it or whatever. They can. But when you are dealing with applications like this, people's opinions don't matter. Let me repeat that. And people have gotten mad at me when I have said that in a variety of places through Middle Tennessee in these kind of meetings. Their opinion about whether you're allowing a special exception doesn't matter. What matters is, do they meet the standards? And so when I have told people that, did that person who stood up and talked either for or against it, did they tell you factual information you think you can rely on that is important to what the standard is? Truly, the only time people's opinion matters is in front of the city council about whether they want something rezoned, because that is called a legislative process. They're making law. They have a right to tell their legislative body, I don't like that law or I like that law. So that's truly the only time that council can, when we're dealing with land use regulation, that they can go, they didn't want it. So I didn't vote for it because my constituents said no. You all can't say that. We would get overturned in a heartbeat if you're like, oh, well, 50 people showed up, they didn't like this special exception. Nope, that's not how that works. So, I'm sorry, I forgot what we're doing. I got off on that tangent about what you asked. I'm sorry, I really did. What were we saying? What was I saying before
Bed and breakfast.
that? Bed and breakfast.
Oh, yeah, I wanted to add to the bed and breakfast. State law has where you can put Airbnbs in anywhere residentially zoned district or residential zoning exists. So it kind of defeats the purpose, because I have somebody that's went through the process of doing the B&B, which has a lot more restrictions where you have to have somebody living there. I think you're limited to 3 rooms, but Airbnbs, somebody decided to pass a state law that says, yeah, you can put them in any residential area.
So what's the difference between an Airbnb versus a B&B? Just that you advertise on a specific website?
Capacity.
Yeah. I mean, there's criteria for that you're part of a, an organization that, basically you have a virtual, I guess, a reservation person.
And that's regulated state. State's
Yeah.
kind of taken that away.
Yeah, so it's kind of, because, ours and our bed and breakfast, you have to have so many feet between bed and breakfast. I don't know, I can't remember off the top of my head because I don't have a lot.
It's almost making our law obsolete.
Well, that's what I was wondering,
Yeah, that's pretty much what it
People
does.
live in a B&B though, right? And they
Yes.
don't have to live in Airbnb. constantly, right? There has to be somebody living in the B and B and there doesn't.
Yeah,
Mhm.
exactly. And then you have to be part of a group, whether, I mean, I don't know what the other, there's Airbnb, but there's another one too.
But for that matter, if I had a B and B, I could just also advertise one of the rooms on VRBO or Airbnb
And then you're
And
then I'm
Airbnb.
covered, right?
Exactly.
It's a,
That-
that
that-
whole
Yeah,
phenomenon
I mean,
has
that's
created
sounds like.
an
Yeah.
incredible, convoluted, and difficult law. It's caused a lot of people headaches.
I bet it
That
is.
it's been a nightmare for Nashville.
Well,
Yeah, parking issues.
Nightmare for
Unfortunately.
Nashville.
Yeah.
Yeah, that you don't get the Nashville lawyers. Metro lawyers talking about Airbnbs.
They're
Yeah,
everywhere.
yeah, it's a
Yeah.
mess. I know where we were. I was talking again about your authority. Again, 60 days, and that's why I always insist. Even if all you're doing is approving your minutes, when you have approved something like an application, it is crucial that you come in, because I've seen places and I'm going, I know you approved it 8 months ago, but you haven't approved your minutes, so technically their clock has not started running. And it's a short clock for BZA decisions. Not everything has got that short clock on a writ of certiorari. Oh, that's where I was, I'm sorry. The record in front of you. What's important is that you are examining what's in front of you in the meeting. The documents, we've got to be very clear that the applicant knows what the documents are. Here are the documents that you're examining. The record, oftentimes, and Lisa would normally know, if something's probably controversial, we keep our recording because we probably will have to transcribe the audio recording of the meeting, and we send that to the court too. So the court gets the record, the official record. Everything that was presented to you for you to make your decision is in the record. And we send the record up to the court. The court examines the record. It's the job of the court to see if there was some sort of error made. If you made an error, really in procedural law, it's not the court's job to substitute their decision for your decision. It's not what we call trial de novo, that they get to look at it and then make their own decision. That's not what they're doing. They're looking to see if you made some type of an error. That's why it's called a writ of certiorari, because it's a writ telling us, get your record, get it filed. And so all the court is supposed to be doing is doing the record. On occasion, if it's called for, and if the party that wants additional evidence brought in, sometimes a court can allow additional evidence. So this is not like what you regularly think of a trial. You go in a trial and the lawyers are ending in and bringing witnesses and doing. That's usually not what we do at a writ of certiorari type of a hearing. We are simply arguing what's in the record in front of a judge. So I forgot, that's where I was. I wanted you all to understand what that is.
And if you'd like, there's several documents from the American Planning Association that has like critical, all these critical decisions that were made. Most of them are from Supreme Court, but not all of them. Some of them are district court, and Supreme Court just said, we don't want to hear the case because it's usually it's pretty much settled on that. And, but it lists out all the very critical ones that are in land use history, so it goes back.
We've only got about 6 minutes. Let me touch briefly on a couple of other laws that is about procedure that I want you all to make certain that you are aware of and how that plays into what we do. I'm sure you all have heard the Sunshine Law in Tennessee. That is our Open Meetings Act. Clearly, we're an open meeting, meaning that the public has a right to come to all of your meetings. As a part of that act, there's also some procedural things, and Lisa Smith is the lady that keeps us all in track. She knows that like the back of her hand. She has to keep up with a ton of different boards and what all they do and when they meet and all their meeting notifications. So we have to send a certain type of a meeting notification to let people know what's on your, that the board is actually meeting. We actually now have to, when I was telling you about, we had a law change in the summer of 23. that requires you to have a public comment period at the top of all our meetings. We also now have to publish the agenda. We used to not have to publish the agenda. We just had to publish a meeting notice that the meeting of this board is taking place on this date at this time, whatever. We now have to publish your agenda. The law is a little bit different. The meeting notice has to go out earlier. The agenda has to be posted at least 48 hours in advance. And the state law gave us some grace by saying, we think you meet that law if all you do is post your agenda on your website. So that's what we do. We post your agenda on the city's website, so anybody can see the agenda. And then the other thing that our notices have to have on there is if you have a procedure or a method that you make people go through in order to speak at public comment time, you have to put that notice at the bottom of your meeting notes or on your agenda. There are some places that require, if you wish to speak during the public comment period at the top of a meeting, that you call them in advance or email them in advance. We don't do that. The city rejected that immediately overall. I suppose you all could make your own bylaws. I can tell you, I don't think that would be, look, you could probably change that in your bylaws. I don't think the council would look kindly on that. The council, I'm very proud of the city of Shelbyville. For years, they have allowed citizen comments. They don't have to, but they've done it for years. They do that at study sessions where you can bring up anything. At the end of their study session, you can walk in and say, council, I just think you need to know about this. And they would let people speak. So I've been very proud of the city of Shelbyville for adopting that many, many years ago, in a bid to make certain that their citizens had access to them and they were transparent. Now it is state law that everybody has to have that public comment period. But the state law says that it is germane to the items that are on the agenda. So people can't just walk in and start talking about feral cats. That's an inside joke if you were here at that time. So it really has to be on your agenda. I will tell you that there is a bill in front of the Tennessee General Assembly right now that may change that. So that during public comment period, at the top of any meeting, anybody could speak about anything. Now, I can't wait to hear if that means that my beer board has to listen to feral cats. You know,
Mine's there.
you were a feral cat, you actually know.
I can give you,
I will never forget that feral cat
I was at
presentation.
a historic commission when the applicant came in and complained about their neighbor's nude art in his backyard that he purposely put in there because he was upset. He could see in her bathroom window and she refused to cover it up.
Well,
I do think though, if the state does pass that law where, you can come talk about anything, that would be a good time for the council or the different boards to put in place a set of restrictions to make it where, you do have to jump through some hoops to come talk. That way we might not have the feral cat conversation.
well, let me tell you what the city has done, and this is one of the things, and I kind of wanted to even talk about bylaws, but we've run out of time. We can talk about bylaws later on the actual meeting agenda. You can put in restrictions, and the city did that on how long you could speak or an overall. The state law said that. So the city's public comment time at both their study session, at their city council meeting, is a total of 15 minutes. And we limit to 3 minutes per speaker. And we actually put a timer. Kay puts a timer up there on that. So they're standing there, they know how much time they've got. Lisa does a really good job. She puts out a clipboard with a sign-up sheet. All the city does is like, if you
There
want
you
to
go.
just come to our meeting, huh?
There's the time, there it is.
There's a timer. Thank you, Kay. And that you sign up your name, and we ask to tell us what you want to speak on. And the reason we do that is the law also has sort of a general phrase that says the city, county would take pains and make certain that all viewpoints have an opportunity to talk. So Lisa does a really good job. I mean, she's on it. She gets up, she lets people know 15 minutes before a meeting, hey, if they're in here, she's like, we have public comment. If you want to public, please come up here and sign. She does it again, like right before the meeting starts. So she'll bring that clipboard up here. The mayor then refers to her and we just go down the list. If we feel like we've got more people that are going to take longer than 15 minutes, both her and the mayor have reached out and said, if you have a different opinion, is there anybody, is your opinion different than what the person that just spoke said in front of you? And we've had people say, I was going to say the same thing, I'm fine. So the city takes pains to make certain that if anybody, that we're not cutting people off with 15 minutes, we don't want to do that. But I like the 15 minutes as well, because if you don't, you get a feral cat presentation that goes on for an hour.
Do they have slideshows?
Yeah. It went on for a long time. And because you just simply can't keep having basically a public hearing that goes on and on and on and not get to the business of whatever the board is. So that may be something that we all want to do in your own bylaws, is adopt some rules like that. The council adopted it for themselves. We need to really probably each board adopt that for your own self about how you want that done.
Do you have to be a city resident or a city property owner?
We have not made that requirement.
Yeah.
We've not made that requirement. Now, in the past, I know we have asked people to identify where they live on really controversial issues, because folks is like, that person doesn't even live in the city. They live in
Yes,
the county.
and we had an example of that in Fayetteville, where there was I can't remember there was a school that was, excess property that was disposed of. And this developer bought it, wanted to turn it into some type of rehabilitation, drug rehab facility. And it was near a residential area and highly opposed. Well, so the neighborhood brought a whole bunch of people together. 80% lived outside in the county. Didn't even live in near the place, and it wasn't. There's a little backstory behind it and everything like that, but it wasn't even brought up during that meeting. But
Lisa, we don't make individuals put their address on that sign-up sheet, do we? We did in the past. The
Yeah, we
city
used
used to make people do that so that we would know. Because when we originally started doing citizens' comments at one point, actually, this was during a public hearing, not actually citizens' comments. They wanted people to come up to the podium and state where they lived. And we had a woman object to that because she was I live by myself.
Yep.
I live a little bit remote, and I don't want this going out on the airways where I live.
Yeah.
And so we backed off that because of that request from that woman. But we still used to make them write their address down, but we've just backed off that.
Well, it's still on the form, but they don't fill it out, and I don't, push them for it. We do kind of try to push them to put what they're to speak about
Right.
and a phone number. So if they bring an item to the council and the council decides that, well, that's something we need to look into, they want to be able to get a hold of that person that
Right.
brought it to them. So we do ask, try to ask them if they'll put a number down there where they can be reached. But we don't really enforce the address they need.
Yeah.
And so to wrap up, I know we're going on, we've almost had a full hour. The open meeting law, just remember again, don't have full-blown conversations about something that's coming in front of you out in the public. Remind them, I tell my planning commission all the time, blame it on me. Tell them, we've been trained, Ginger Schaffner, Sam Edwards, everybody that's come down here and trained to say, don't do that, come to us. Also, if you ever receive an email about something outside that someone has sent to you, not the city, but someone else, because this has happened to my planning commissioners more than once, make certain you send that to Tom. Because that may be relevant to an item that you have. Send it to Tom so we can distribute it to everybody and make it be a part of the record.
Yeah, usually it has to do with complaints. People will complain and then we enter it as, hey, we received so many complaints or.
But you may actually have someone that comes up to you and says, I want to talk to you about this thing that's coming up in front of you, and I want to submit. I've had that happen to 3 of my planning commissioners over the course of the years, and we've all, they've been in training, and they're like, I know I need to turn that over, and they all mostly have a spiel that said, if you want to be heard on this issue, you need to come to the meeting in which this is being spoken at, so that everybody hears you and it's on the record. So, same thing for you all. And also note, we're subject to the Open Records Act as well, our Public Records Act. So things that we send you, you send back to us, open record, unless we feel like it may fall under a lawsuit in our privileged, attorney-client privilege. It might, but we really kind of have to be in a lawsuit or almost at a lawsuit before that comes in. I just remind you that. So, 1, don't violate the Open Meetings Act by having conversations about things outside this meeting. Don't do it via email. And if you get something from somebody, make certain you send it to Tom so we can distribute and everybody has it. All right. Is there anything? That's rushed. Broad brush over a lot of things. Any questions?
How are we doing as far as any litigation recently or anything outstanding out there now? As far as any of the decisions been made?
Mm-mm.
Good. Good. I was just curious.
Mm-mm. Mm-mm.
The other thing.
The BZA had, we had a really big one many years ago. And that's when our planning commission our larger planning commission acted as the planning commission and the BZA. It was because of that lawsuit, we split it. Because of that lawsuit, we split it. So it was just too close and we're like, we really need those people to be separate.
Yeah, trying to think of any big cases in the broad area because usually, like our big thing is we have to just make sure that we, are providing due process. So when an application comes in, we have to make sure it's complete. If it's complete, it keeps moving forward until some other body basically turns down or stops it. But most of the times, we haven't really had anything that's been.
I'm sitting here trying to think the last time we had somebody actually challenge the decision of the BZA.
That's great.
I will say that.
I think it was the very large one we had.
I will say
And
that.
it's a nightmare.
Well, the
It's a
BZA
nightmare
meeting
case.
was 7 hours long. We started at 6, we got done at 1 in the morning, and the mayor almost died.
Oh, wow.
He had to go to the
Oh.
hospital.
Is that the feral cat one?
No, that was
No.
a council meeting.
We're talking about the right paving.
Oh,
lawsuit
yes,
that the
yes.
city eventually settled. It was multiple rounds. It took almost 10 years. It went on and on and on and on.
Yeah.
And that's why I tell people there were so many multiple issues in that case. But the small details on procedure, not even at the BZA level, but administrative staff following procedure to meet state law, to meet what a notice requirement is basically what those cases turned on. If you hadn't had that hook that somebody could say, oh, you didn't do the quite right, that case would have died. They would have said, done. You can't even go and bring up these other issues, which is why I know people get tired, but I hammer on small things sometimes. And I know people are like, why? I'm like, because eventually it might cost you $3 million.
Yeah.
You have to pay attention.
Now, I was part of one where the Court of Appeals determined that rubbish is rubbish. It was,
Well,
I would say 7 years long.
my claim to fame, and I'll get asked about this every once in a while in a training with a bunch of other municipal attorneys, is the Bedford County case, Bedford County BZA. Bedford County, the city adopted zoning in 1962 or 4 is what I think. Bedford County didn't have zoning law until 1998, and I have done all of their zoning ever since then. Yes, I've done all of it since 1998. And one of the first cases they had was a Lewis case, and it was not even settled law in Tennessee about, at that time, about the responsibility for creating the record in front of the BZA. At that time, it was one of the first cases we had. They didn't record their minutes, or not the minutes, they didn't record the meeting. There was no audio transcript of the meeting. So I walked into the Court of Appeals down in Nashville and argued they can't prove what they can't prove what happened in that meeting. They didn't bring a court reporter. Well, Bedford County got slapped down, and it's now the law in Tennessee that it's our burden to have a recording, a good recording, that you could be able to create a transcript. So every once in a while that gets brought up in some kind of training, and I'm like,
Yeah, it's funny because one of the criticism of what I did was I put multiple ways of appealing something within, because it had to do with just property rights. I'm a property rights advocate, and they just said that I didn't need to do that. But ultimately, trash is trash.
trash is trash.
And I think what was the title of it? One man's trash is another man's treasure.
Let me tell you one thing right quick, and then we'll jump back in, that we've had some conversations about that we, staff, think we need to change. One of your trainings that we need to do a whole hour on, maybe 2, is the Tennessee Vested Rights Act. Very important. You can get vested rights in Tennessee you can get it under a variety of things in terms of land use. It can arise under the zoning ordinance. It really rises more under subdivision regulations and plats and preliminary plats and building permits and all that stuff. We have just discovered that we need a process by which someone could challenge, or the decision-making process on whether the city thinks somebody have lost their vested rights under state law. So just so that you all know, we have a current matter that is a preliminary plat that was approved by the Planning Commission. They did not meet the 3 standards you're supposed to meet under that act, that state act, within 3 years. So the city has notified them that they have lost their vested rights. What that means is you can no longer build that subdivision under that preliminary plat. And we have new laws in place. Now you've got to come back in and redo your plat and under our current laws. So what we discovered is we don't have an appeal process on that. We didn't really know who made the decisions. We've let that be right now that Tom has made that decision, because it deals with something that arises out of subdivision law, subdivision regulations. We have notified that person that they could apply for a variance to the Planning Commission, because we didn't think it technically met the definition of an appeal to you all, because it doesn't rise out of the zoning ordinance. It rises out of subdivision regulations. So we became aware of that. We want to write it in the zoning ordinance that things that come and arise out of a vested right question that arises out of the Planning Commission, their jurisdiction, we want it to go to them. If it's a vested right that has something to do that rises out of the zoning ordinance, we want it to come to you, because that's your jurisdiction to
Yeah, it's
interpret
rare.
this. It'd be rare.
Yeah,
It'd be very rare for you all.
Yeah, I asked Chuck Downham, who used to be our MTS advisor. He's never had a case, and most places haven't had a case.
Except Knoxville, they love to tell me about their cases. It's elaborate.
Yeah,
It's elaborate.
and the state worked, I think it was like 4 years to actually create, everybody kind of settled on what those, like,
Vested
what the
rights.
time frame is for vested rights.
Let me hit right quick for what I'm talking about, vested rights. There was an issue, I think, all across the state for developers who want to do big subdivisions.
Right.
And so they go through all the work, thousands and thousands of dollars of developing a development plan of here's how we're going to build this subdivision. And they come in and apply at that point. Well, oftentimes local governments were like, "Ooh, we really don't like that law. We need to make that tougher. We need to change it." And so there was uneven enforcement along the way about people trying to, "Oh, you've spent all that, but now we're going to make you do it this way." So that's what vested rights are. It was needed. I think it's great, but it stepped out. You must, so for a preliminary plat, you then have to do a more final development plan. For the city of Shelbyville, that means you got to bring your construction plans in that our engineer reviews. Once he signs off on that, number 2, you have to have your building permit. And then once you have your building permit, the number 3 thing is you have to actually have started site preparation. Let me back up, not a building permit, a grading site.
Yes.
Grading permit, excuse me, just to get the ground ready. It's a grading permit. Then you actually have to start site preparation. And it's a minimum on site preparation. You have to do all of that within 3 years of the approval of your preliminary plat. We have a pretty clear case that
Yeah, because
they didn't
after
do
3 years,
that.
yeah, after 3 years, if you do all
Then
that,
you
you
lose
get
your vested
additional
rights. You got to
Yeah.
start all over again. If the law's different.
Yeah.
But if the local law is different, it's still the same, it doesn't matter. But the Vested Rights Act talks about the city can allow upon, basically the folks can request, please allow us to continue under our development plan, even though we've lost our vested rights.
Yeah.
And we don't have that procedural structure.
So like if we up the green space to
Mm-hmm.
30%,
Mm-hmm.
then they would have to go in under they'd redo their plat.
That's correct.
30% instead of the 15 or whatever it was, or 10 or.
So everybody that's got a preliminary plat that's already approved, they've got that 3-year window. 3-year
Yeah.
window to get that started. And once they start, meet the 3-year, then 2 more years gets added
Yep.
on their construction. So it's a long, I don't want to make it sound like it's an easy statute. It's not an easy statute to read and apply, but it was needed. It was definitely needed.
How much site preparation has to be done? Like, is it a
When it comes to-
finish?
Go out there with the shovel.
Not much.
I mean, yeah, that's what I'm saying. Like, is it
Technically, a lot of people, if you'll just go out and put your construction board up.
Yeah.
real?
Tree removal is one.
Tree removal.
Knock down one
It
tree.
doesn't take a lot.
It doesn't seem.
Well, that makes sense. I gotta see.
You gotta put one tree.
Yeah.
Yeah.
I think folks really, it was difficult. This law was
Yeah.
a
They
challenge.
work
It was
for
a
you.
fight on this vested rights. And so there is, and I meant to say this early overall in my training, know that in general, land use regulation, when you're trying to apply a law to somebody's land, courts generally will read that law as favorable as they can to the landowner, not the city. The burden's on the city. Shouldn't say the burden necessarily, but they will tend to read the law as generously as they can for the rights of the landowner. And that's definitely would be the case in vested rights. So I think no one wants to go, if you did anything out there, you started site prep.
So a sign or anything like that.
Coming soon.
But if not, it would
Well-
discourage any.
Knock one tree.
I don't know about a sign that says coming soon.
I know.
It's like knock one
Yeah.
tree down and.
Well,
Or put a little
yes,
gravel
but you
down.
need to,
Yeah.
I mean, put up your construction board where you've got here's
Yeah.
my
your
permit,
purpose.
here's where we're ready to go, here's what we're doing, that kind of thing.
You're gonna dump a load of gravel at the end of the.
I think, what I have gathered is your staff does not want to challenge that. They think that's a waste of the city's time to challenge that. Now, they also can't go out there and dump it and then sit for 3 more years.
Yeah, there's.
Then they got 2 more years to get it done.
So you have 2 more years for the
Yeah.
construction to happen once the site is.
Yeah, you have a total of 15 years altogether to go from start to finish.
But those are multi-phase
Big
projects.
projects.
Yes,
Yeah.
that's why we say it's sometimes difficult to apply, because you've got to understand you gather more time as you go through and meet certain deadlines.
Yeah.
And that's only on a particular, if you've got multi-phase type things.
So if Betsy starts a subdivision and she's 2.5 years into it, and the regulations changed in the meantime, she's fine. What if I buy that from her?
Runs with land.
Yeah.
So I can continue.
It's not to the person.
Yeah, it's approval of the, your property. Yeah, and subdivision, in general, you have your preliminary plat that gets approved by planning commission. You have your construction, which is done at a staff level of the engineering part of it. Then you move on to your as-built recording. And then after that is your final plat.
We give an hour and a half credit now because we went over. So that's
We'll take it.
Well, thank you all very much. I
Thank
appreciate
you.
you participating. It's more fun.
Don't worry, my heated.
Lecturing you.
You make a contribution.
It's freezing.
Yeah, this time of year, we can't ever.
I want you all to know, if you don't have my cell phone number, you can call me or email me at any time. Do not hesitate to, and if you have, if you like to actually meet with me or meet with me and Tom, and I've got questions in general, we'd be happy to do that for you. Okay?
Thanks.
Absolutely.
ready.
So, oh, actually, I should have put that in there. I'm gonna put the subregs inside there too. Yep, I'll put both subregs, I'm gonna add subregs to this and then update it as well, so. But those will be yours.
So do I need to leave this here?
Or
just leave it, or just get it whenever you bring it up?
Yeah, you can bring it back to me, I'll just let everybody know it's ready.
Okay.
Yeah.
All right, we will call our meeting to order. We will start with roll call.
Chairman Williams,
Here.
Member Perkins.
Here.
Councilmember Noel,
Here.
Member Patterson,
Here.
and Member Armstrong.
Here. Everybody's here.
Yes, sir.
Approval of the agenda. We have the agenda before us. We will entertain a motion. Before we do that, and I don't know if we even can do this after what Ginger said, is there also normally we approve our training that we just did, or
We'll do that next
do that next month? All right, so we will entertain a motion to approve the agenda.
I make a motion for you.
Motion second,
Second.
3 seconds, all in favor? Okay, motion carries. Approval of minutes from the last meeting. Those in the Dropbox, believe.
Make a motion.
Got a motion to approve those? Second?
Make a second.
Got a second, all in favor? All right, that one passes too. There are no constituents, so I don't think there are any comments there. There's no old business, and new business is just the review of the BZA bylaws.
Yes, that, didn't know we had, or I didn't know that there were, I didn't have a copy of it until Ginger gave it to me.
Yeah, something came up recently when we had to go back and look at the planning commission bylaws, and I was like, we need to probably look, I hadn't looked at the BZA bylaws in a long time. And so it looks like we haven't reviewed them, just to see, do we like them? Do we want to change them, whatever, since 2015, so it's been about 10 years.
Yeah. And
So,
Just right off the bat, I see something that I'm not gonna say I don't like it, but I have questions about it. So
sure.
this is a 5-member board, according to the bylaws.
Yes.
But it looks like we could have the mayor and a council member serving as 2 of those 5 members.
Mhm. And let me back up. One of the things about this section I made sure to bring out to Tom is you all don't set that law. The council sets that law. That's actually in the zoning ordinance. So I'm not sure why somebody then repeated that in the bylaws. That is not a proper, if you want to say, that's not a proper subject for the bylaws. You all don't set how many members, the terms, any of that. That's set by council. And that is actually set in your zoning ordinance. That's how they do it. They pass the law. And so that's why I was like, it looks like somebody just added that in as a copy of what is actually in your zoning ordinance.
Yeah, and usually if I were to do something, I would just refer it back to the zoning ordinance.
Well, I do think in that case though, that, you said, or up stuff to you that needs to be changed. I think that should be mayor or council member. I don't think that, over a third of the BZA should be, one of the things with the BZA, again, I've been on it a long time, but one school of thought is no elected officials on it.
Mhm.
Because again, what Ginger said, we have to go by the facts. When you're making a decision here, it doesn't matter what your constituents say.
Right.
It matters what this says. But when you sit in the council, when your side's different,
Right.
it matters what they say.
Right.
So,
Right.
and so that's kind of a little bit of a conflict, but at the same time, so for that reason, I don't like an elected official on the board, but I do like having a council representative, whether it's the mayor or a council member, because we talk about the same things sometimes, and it's good to have someone that knows what's going on in the council minutes here, but
And I don't think anybody's talking about changing that.
no.
It was just, as I was reviewing my whole point was, please understand, you all do not have the authority to change this. This is not something that goes in the bylaws. It's basically a restatement of what is it Article 7 again?
Yes.
It's Article 7.
So
And I think the copy that you all have may not even be correct. Did you include the latest ordinance that set up
I did.
for them?
There was a 2013 one and a 2021.
We discovered back in 2021 that in a major overhaul of the zoning ordinance in 2015, 2017, I'm not sure when, there was a major overhaul. The structure, appointment, membership of the BZA got left out of the zoning ordinance. Kevin Chastain caught that error in 2021, and we went back and fixed it. So this is what I mean by codification. Codification is when all your law is in one big document. We change the law all the time by separate ordinances that don't necessarily get administratively pulled into one big document. We codify over a period of time. Like, okay, here we've got 17 different ordinances that have changed this one big document. We need to physically go in and make typing changes to this big document. That's the process we call codification. Lisa,
We
could you
call it
explain that better
worst-
than that?
We call it our worst nightmare.
There she
And
is.
to your point, Chairman, under, well, the later revision actually took out, that the mayor or a council person is on the Board of Zoning Appeals. It says pursuant to the provisions of Tennessee Annotated Code sections annotated 137205, it's hereby created a municipal Board of Zoning Appeals, hereinafter referred to as the Board of Zoning Appeals. The Board of Zoning Appeals shall consist of 5 members. One of these is a member of Shelbyville Planning Commission. All members of the Board of Zoning Appeals shall be appointed by the mayor and
Rick,
confirmed.
did you say one is a member or no more than one may be?
One is a member of the Planning Commission, and
We
all
don't
members.
have that.
Yeah, all members of the Board of Zoning Appeals shall be appointed by the mayor and confirmed by city council.
Yeah.
Where's that? Here.
This is in the.
Because it goes,
It was actually left out of that edition. That's why we need to do a more comprehensive update to the zoning ordinance that includes this section in there.
so what are you reading from the zoning ordinance?
This was something that was done in
This is
2021.
21. This is the correction.
Yes, this was a correction that was done by Kevin Chastain in 2021.
I want to make certain our two new people know what we're talking about. The document that he gave you that looks like, and it says at the bottom, your overall large zoning ordinance, thick document, and it'll say here at the bottom, April 2017. That means whatever the law was in April 2017 is codified in this one large document. Every single change to that document since 2017 has not been administrative secretarially added into this document. Does that make sense?
And that's why.
So
it's
Lisa,
missing.
I drive Lisa crazy all the time and say, I'm interpreting this section of the zoning ordinance. I need you to check the minutes to make certain there's been no change to this document that I'm not seeing. I want you all to know that we are in the process of taking our law in the city of Shelbyville to a new type of program that we will codify every 3 months. And so people will be able to read it online,
Yeah.
including our zoning ordinance. That's going to help us tremendously.
Sure.
Yeah.
So that's what we're talking about. And so he's reading a document. The document he's reading is an ordinance passed, went to the planning commission, it went back to the council. It changed your zoning ordinance to add back in your structure, how many of you on here, when you're appointed, all that somehow or now got left out in 2017.
So that means that somebody from the planning commission should be on the seat and I should not be on the seat.
It doesn't mean
Pretty much.
you can't be. It doesn't mean you can't be. It means that we are supposed to have someone on the PC sitting on here too.
Do you have any idea why? And that's not maybe just an error? Because
I don't remember.
we specifically and purposefully separated the two boards with zero overlap.
Kevin
Although
drafted all that, so I
Yeah.
don't
it
I don't have any recollection.
is in here though where it says that no more than one member shall, no more than one appointed member of the BZA shall also serve. So it doesn't say one has to, it says no more than one.
Yes, and so state law also, we'll need to go back and make sure what the state law says about membership, because sometimes state law sets things you have to do. Sometimes it sets things that you're allowed to do if you want to. And so, I mean, because the BZA can even be larger than 5. That's the smallest it can be for us.
Yeah, so Tennessee Code 13.
No, it could be 3, I'm sorry.
Yeah, 137205, just says that, you can create a BZA of 3 to 5 members, 7, 9 members. May specify the mode of appointment. Let's see, there was something in here. They may designate planning commission, as a board of appeals.
It doesn't
Yeah.
appear to me to require a mayor, a council
Yeah,
person.
it
It doesn't
doesn't specify.
require anything.
It's very
It
general.
says
broad.
the council can set up the structure. So I think it gives, the council then can create in its ordinance how that, if they want, if they wanted a member to be an architect, if they wanted, they could set up those types of parameters.
Yeah.
So I don't know if someone just some time ago got confused and
Yeah.
thought that instead of a planning commissioner was thinking a council member.
Well,
I don't know.
And who knows, maybe they thought that a planning commission member on here would be beneficial. But
Kevin drafted that, Kevin
Yeah.
found it and Kevin drafted that, so we could
Yeah.
ask him.
yeah,
Yeah, because I mean, if that's what the zoning ordinance is, then we're not meeting the zoning ordinance from our meeting.
Right.
That, I could see that could be not good.
Somebody could challenge that if they really didn't like something that had happened, they'd want to throw a fit.
Yeah.
I don't think that would probably be something that would be overturned a decision would be overturned, but we do need to address it.
So we need one of y'all to also join the planning.
Well, let me say, as a part of what I wanted, I told Tom, we need to clean up our bylaws.
Yeah.
Because I feel like the whole section of the members, that just needs to come out. You are not doing that. That is not your authority. I don't want anybody, I'm like, doesn't have to say any of that.
But I think Article 1 in the zoning ordinance should be cleaned up.
Yeah,
Anyways,
and sometimes in the bylaws, I mean, I've placed where it only, like under members or authority or anything like that, to refer back to that section.
Right, you would refer it to the zoning ordinance.
Yeah.
So you all have the ability to clean this up, but the other thing, however, is what I said earlier. If you all see things that like, here's how we think that should be structured, that you then want to, hey, take that to council. That's their job to do it. Let them know this is our recommendation. So that could be a part of it. We need to clean up something in the BZA section of the zoning ordinance anyway. I anticipate having to take something to council. So if you all have recommendations and if you want to say, hey, we're not even in compliance right now with this planning commission member. Council, do y'all want to look at it? We think you need to change that. Maybe you make it the mayor, maybe you make it a council member, whatever.
the way that actually, because even this is wrong, what we have.
Yeah.
It's correct.
It's not correct. Mhm.
Yeah.
So this is.
And so now's the time. If we'll take back to council whatever you have an opinion on and feel like want to make a recommendation. Because this was the whole thing. I'm like, we need to clean this up. We need to clean up, make sure the ordinance is correct, cleaned up, and that our bylaws are in flow with what our ordinance says. And then if y'all want to add something, change something about your procedure, we will.
Well, even on this ordinance under member terms, it's like.
That was what I caught. I'm like, there's some things, we did catch a lot. Kevin caught a lot and fixed it, but I was like, we didn't completely fix it. We need to go back and and amend that section of our zoning ordinance to make sure we've got it all covered.
I think personally, the way I like is, again, 5 members, no more than one can also be on the BZA, where it's not a requirement, but they can be. If the council feels that they want that overlap. But then instead of, where here the mayor may serve and then the remaining 3-year terms, also a council member, I think it should be the mayor or a council member.
Mm-hmm.
I agree with that.
And then 5 or 4 other just
Mm-hmm.
regular citizens
Both of us should be here.
do it.
I don't think both of us, or 2 people from the council should be on.
Now, I've also
We have
seen,
that at the planning commission, but the planning commission is a larger board.
Yeah.
We have both the mayor and a council member, and I'm sorry, I can't remember what the planning commission state law is on that. That may even be a requirement or state law. I don't think it is. I'd have to go look.
I think I've also seen with some boards where maybe a council member is on the board and can participate in discussions.
Ex officio?
Yeah, but can't vote.
We can't vote.
So I've seen that before, but again. But that, I mean, do you all kind of agree
I
with?
agree, Tony.
Yeah.
I agree.
I did look it up right here. Planning commission, under state law, it is required there's a mayor, it is required there's a council member. That's state law. BZA state law, I don't think so. I don't think, it could be whoever the council wants to be.
So will you make those recommendations to the,
Yes, we'll be happy to. Yeah.
also,
What was it you said? I'm just trying to make sure.
5 members, instead of requiring one also be on the planning commission, no more than one may also be on the planning
Either the
commission.
mayor or the council. One.
And then either the
One of
mayor
the
or
three.
a council.
One of the
Can
three,
be-
if it's any, right?
Right, and so I,
It's just there.
and so I take it, to take off a member of the planning commission,
Uh,
or do you care?
Well, I kind of like what it says here where, no more than one appointed member can also be on the planning commission.
Gotcha,
So,
right,
I think
Which could be up.
thank you,
This
Tom.
is
Actually, no.
under Michelle.
Doesn't have to be, no more than one.
there should be more than one.
Right. We did want to create that, sometimes it's good that there's some communication between the PCA and the planning commission, but we really did feel, based on how that whole thing went with the right case, that it was best to keep separation.
Yeah, because we were all together, we were the same board, PTA, we would end one meeting and start the next with the same people.
And they had to put different hats on as soon as
Yeah.
they did that. Keep it up, keep it down.
Thank you.
Was there anything else that jumped out at you?
Nothing else, I mean, to me anyways, jumped out. Unless we wanted to add language to it about, how hard is it for us to amend our bylaws? Just bring it up at a meeting and amend it, right?
Send me what you'd like to,
Your bylaws are your authority.
Yeah,
They do not have to go to council for approval. I would report to them what you've changed. but-
and I'll do a resolution, for BCA.
I think I like the bylaws like they are personally. I do think once a decision is made at the state level about the public comment, no need putting anything in there additional about the public comment if it's gonna change in 2 months or 3 months or whatever.
we need to go ahead though and structure something in here for you all to consider about how you structure your agenda, do public comment, and you all make a decision on the restrictions you might want to do on public comment. If you want to adopt 15 minutes or not, or if you want to adopt 3 minutes per or not. I mean, you really don't get a lot of people. You generally don't, unless you get something incredibly controversial, like a rock quarry.
I think,
Then you get
So
tons of people here.
Can I also make, oh, sorry.
how's the 3 minutes been working out?
The overall restriction on public comment is no more than 15, everybody. We reserve 15 minutes. For each speaker, you are limited to 3 minutes. So in essence, only 5 people can speak.
Yeah.
And that goes back to why I said, we ask for people to tell us what you're here to talk about, because Lisa says, is there anybody here that wanted to speak on a topic that has not been spoken on? Because the law says we're supposed to make it fair, because everybody got to speak. So if that situation hasn't arisen yet at city council, but if it happened, I know what my mayor, we're all like, we're going another 3 minutes, add 3 minutes, we'll be 18 minutes, but that person needs an opportunity to speak. So that's what we would probably do.
on page 3 of 4, section 3, any citizen wishing, or point 4 rather, any citizen wishing to address the board must make their desire to speak known by signing in, providing their name and address for public record. Before commencing their comments, citizens must verbally state their name for the public record. And then 5, the chairman may open the floor to public comment, if any, after the zoning administrator or designee and the applicant or their counselor/agent have spoken. Any private citizen may speak for or against the issue. They're limited to a maximum of 3 to 5 minutes per speaker. Now, I don't like that. It needs to be a maximum of 3. Yeah. Maximum of 3 or 5. Well, that's, yeah, so that should be.
3.
And let me tell you, this is listed as a format for public hearing. Let me say this, public hearing is a specific term of art. Y'all don't really have public hearings. You have a public meeting. there is a difference
Yes.
between a public meeting and a public hearing. Very, very different. I don't know of anything that a BZA actually has to have a public hearing on.
Yeah, and that was something that came up too from it was a question that was posed of me from, Walmart. They were concerned about public hearing versus public, and I explained to them, well, all the meetings are public. We have a public comment period, but it's not public hearing. You don't get to hear.
And that's what when I said earlier in training that the public has no legal right to come and speak on a special exception application. What I mean is, there's no public hearing right.
So they have
Now
the
what-
rights to come and, under state law from a couple of years ago, to come and speak about anything they want
Under public
in
comments.
the public comments.
So I'm telling you,
Yeah.
practically, that's kind of been overturned because now the state requires public comments at the top of the meeting for anything. And it can be germane to things on the agenda, which means now that people can come in and now talk about the beer permit applications.
Well,
I'm not sure if I've ever seen anybody come in and speak in opposition of a beer permit application, but people now have the right. But under our law, how law has been in Tennessee for a long time, there are certain things that we're passing, there has to be a public hearing about. That's a very different animal. That means the law says before the council can change anything or you can give something, you have to open it wide. You have to give a notice to the people that they have a right to come in and speak on that issue. That's what a public hearing is.
well, I think
You
we
don't have to do that as a BZA.
I think then, under procedure, or under that page, or
Under public
Article
hearing.
5,
Mhm.
basically lines 4 and 5 and 6. Actually, 6 can stay because it talks about time limits, and 3 gives a time limit for the applicant to speak. So leave that, but I think 4 and 5 need to go.
This basically created a public hearing right at the BZA level. Not required by state law.
But
You are
then,
not required to do it, but you created one anyway.
go back to Article 3 under meetings, and we should put something in Article 3 about
Public comment.
public comment,
That's what it needs to be.
limited to 3 minutes per person, no more than 15 minutes total. We'll just adopt the city's.
Right.
Now, in the cities at the bottom, they can come talk about anything if they want to.
That
In the
is,
study session, right?
that's citizen comments
Only in
at
the
study
Only in
session
the study session, though.
at the bottom, right.
Okay,
Mhm.
so that's a difference.
Did the state actually specifically say at the start of the meeting? Or did you say that?
I believe it does.
I think we have to just we have made it. Maybe it does.
I think it
I
does
think it
because,
does.
I think it does because it is to be anything, they didn't say it had to be a topic on the agenda, is germane to what is on the agenda. So it doesn't have to be the exact thing, but it could be somehow related or influence it. And what the state legislature is thinking about just getting rid of it completely, just saying 50, whatever, they can come talk to you.
Anything.
Yeah, and that's what worries me. I'm like, am I going to be talking about feral cats at the beer board?
But we still have a limitation,
And
3 minutes.
Unless
So
they
you
change
can do
that,
that.
but I don't think the bill in front of the General Assembly is changing that. It's more the germane to what's on the agenda is what's up for, let's just get rid of that. You gotta have public comment at the beginning of a meeting and people can get up and talk.
Another thing too, in Article 5, if you go, so again, we're doing away with point 4 and 5. 6 is good. 7 needs to be altered because it says when a public hearing has been closed. So part of 7 is okay. After the applicant speaks, the floor will be closed, not necessarily to public comment, because the floor never was open to public comment there. Or I guess it was because they're public. But it refers, but it, I guess that last sentence, when the public hearing has been closed by order of the chairman of the board, no further public comment shall be received. So I, I think that just needs to be reworded, number 7.
I just want to take out, I just don't like public hearing.
Right.
I want it gone.
Thing.
I want it gone. I don't
Oh,
want you,
well-
I've said that to and I've got clients in other places outside of Bedford County. I'm like, why do you give people a public hearing when you know the danger to letting that board hear people's general opinions that I don't want it in my backyard?
Well,
Because that's what happens.
Can you delete the whole thing?
Well,
Delete the whole thing.
but some of those rules are important. I think it just needs to be titled something else.
They need to be under public comment that's related to a
But-
general public comment at the top,
Well-
not a public hearing.
Yeah.
Because what this talks about, you're gonna give the applicant the ability and that applicant's representative and then somebody else. I don't want people standing up during when you are talking about the application. That's a very different animal. State law, let them talk at the beginning of the meeting. But I don't like allowing the public to talk during the consideration of an application.
So the only place it needs to talk about the public talking is under Article 3. And that's where we have the time limit. Anywhere else where it says public hearing, so for example, in Article 4, just glancing at this, Article 4 point, where did I see that? I thought I saw that up here. Says, procedure for hearing cases. Actually, I wonder if you could actually take the sections
Some of the
Article
sections,
5.
yeah,
that we like and just move to section 4.
yeah, to the procedural part of the, and then something else, I guess it goes to almost at the beginning of it, and
Section 6 up there, I'm sorry, that's
Oh,
what it says, at the
6.
time of the public hearing. In Article 4, 4.6,
On the second.
oh,
it says the word public hearing or words public
oh,
hearing.
yeah,
So
okay.
This was somewhat due to right because of the public outcry of what we dealt with. And folks going and getting on elected officials that they weren't being heard. And I repeatedly, it's a shout in the dark that people's general opinions about something. And so I've tried to educate people. I mean, I've sat down and talked with members of the general public here and in other places to understand, because I've had people then come up to me and said, so you're telling my opinion doesn't matter? And I'm like, let me try to explain what the law is. These people have to apply the law. This is what the law matters to them. And I've had, sometimes it's, people take it and sometimes it falls on deaf ears, which is why I've always disliked public hearing procedures at a planning commission or a BZA, because it introduces the public to think that a plain old opinion matters.
Yeah,
And in state law, it actually is forbidden.
when I go to especially neighborhood meetings at PUDs and, whenever people come in, or they call in for rezoning and it's in their neighborhood, they received a letter. I always explain to them that if they want to be heard, their opinion, go to council. Don't come to planning commission, and you can say, you can comment, but that doesn't mean anything at that point. But what I explain to most people is that if they want to understand the technical aspects of what is being proposed, come to planning commission. And mostly because of the horde that came into a planning commission. And it does it does create a lot of stress for the members, but they don't have to.
So to me, taking out public hearing, and I know why there is often pushback against my recommendation. It was my council's, because folks feel like they need to be heard. And believe you me, I've had most of my chairmen, whether it's planning commission, BZA, this city, county, other counties, they all want to err on the side that they're giving people a voice. I get that. However, I have seen that backfire on my overall client because they've had people sitting on a board who couldn't keep their law straight and were overly influenced by people just having an opinion, and it put their case at risk in a court of law because they made their decision based on the public, and they refer to it as the public. They're sitting here at the table. I've had them go up and say, well, you can see all the people here that are against it. I've had that happen to me, and I'm just like, that will get overturned on appeal. That is not fair to that applicant. All they have to do is meet the standards. That's why I hate public hearings at the BZA and the PC level. So sorry, that's my soapbox.
So Article 3.5 actually gives the agenda, and it actually says public comment.
Well,
But that's also in a bad order. That needs to be reordered where public comment is before hearing of cases.
Well, I think we would put that really at the meetings, and here's what I would do also. I want to refer to the Open Meetings Act, that we are in compliance with it by having a public comment at the beginning of all of our meetings.
But I think just to kind of finish, like I said, redo what we talked about, or make the recommendation to the council about the makeup of the board.
Yes.
And then redo, take out anywhere where it says public hearing. And then put a time limit and just get that order right and just clean that section up, I think. Yeah, like between Articles 3, 4, and 5. They need to be, like, probably 5 needs to go away and some of that will go into 4 and some of it will go into 3.
Mm-hmm. We can work on that.
And then,
Then a pay raise.
I don't know what
Then a pay raise.
and I don't know what the board might think about this one.
I got my beer board. My beer board is like, just ask them. I said they get paid.
So here's another suggestion, but you can toss it out if you don't like it. To insert a section about the duty of the applicant. Any applicant wishing to present an item to the BZA may schedule a pre-application meeting. It shall be the duty of the applicant to become familiar with the regulations, policies, and procedures of the town or of the city. I don't know what the thought is behind that, here's the reason why. In essence, anybody can make an application. Anybody that wants to make an application. But there are some who, the fees are generally set as a way to curb abuse. But there's others that just do it just to say, oh, let me see if I can do it this way. And it's clear that there is no way it's going to actually need any type of approval. Case in point, I've got this one property that has it was actually done without any type of approvals. It has a residential and a commercial on it. And I want to say it's in an industrial zone. And their business is on the property and they wanted to, and I don't remember what I think they wanted to rezone it so that they could do something with their business. I think that's what it was. But then they wanted to come to BZA to appeal within our regulations for something. I just don't remember what the particulars of it was. But it was clear, and I explained to this person that it was not an application that you could make the BZA, and ultimately they dropped it. But it's one of those things that.
We can't talk about it right now. We have.
No, I know that one too,
We
I
can't
like
talk
that
about it.
one
I wanna
too.
talk about it, but we can't talk
Yeah,
about
I know, like that one, but
Like that
very similar, very similar.
They're
It's
very,
like,
very similar.
let's just do whatever we can to see if we can do it.
Let-
And ultimately, this person on, who has this house and a business, just dropped everything and just,
Let me say that Tom, if you all don't know, Tom is an alderman for the town of Wartrace. I'm also the town attorney for the town of Wartrace. And so we have a different zoning issue that he sits on as a member of the board, not as the planning director. I always err on the side of caution on that, even if, because here's how I believe for all applications, and this is why it's a little bit different how we talk about ordinances that are just something that council wants to change versus something that a person has come in. They have a right, whether it's a business they want to run or liquor stores where we have to do those application approvals, or rezoning application of PUD. Those are applications that people have come in and are asking, that's a request to the city, and they usually pay a fee that goes with it. I err on the side of caution. Somebody comes forward and they want to make an appeal to the BZA, and I'm like, yeah, that really doesn't fall in their jurisdiction. I'll make an attempt to explain that to them, but they're like, no, I think it's fine. We're putting it on your agenda. And that will then be a decision for you. Hey, that's really falls out of our authority. We really don't think that is an interpretation. It's not a zoning, it's not a variance, it's not a special exception. Those are pretty easy to tell if you've got it. But if somebody's trying to challenge and say this is just an appeal of something he's made a decision on, it's really not a decision. They're trying to get around other law. Know that my recommendation to him is like, it's still going. It's going to go on their agenda. We will explain what we think the law is, and we will let them decide whether or not we even have authority to hear this or make a decision on it.
I think having the appeal process laid out and, to use one of Ginger's words, codified in the rules is a good thing.
Yeah.
I don't necessarily know about when you were saying that, my thoughts were, could you try to be less, not you, but like you're telling people, could you try to be less stupid? And I want to tell people that every day, but that's, but I don't, because also I think part of it is, yes, if I want to make an appeal, I truly feel that the onus is on me to know what I'm appealing and why I'm appealing it, but also there's a little bit on the public servant to explain that to me.
That's correct.
What about that
Correct.
section in Article 4.2? And that's just basically, the onus is on them to provide. I mean, I think it's implied, yeah.
I mean, they do. They have to make their case. I mean, it's not, they have to make their case to you. So if they fail to make that clear, yeah.
They may not know that they know.
But I would request, like I said, if you all work on those things that we talked about and, email out, before the next meeting or whenever.
Yeah, I can put it on the agenda as a review of a draft format or something like
That's
that.
exactly what we need to do. We need to get your draft for you that you all can see and talk about again. Based on how these bylaws are written, you then wouldn't get to vote on that until the meeting after that. Make sure you all have plenty of time.
Yeah.
And we have to do it at a regular meeting. We don't do it at a special call meeting. It says that. I want to follow the bylaws as much as I can.
Yes,
Oh, what it says.
yes. And eventually, because within the bylaws, it talks about notification requirements and special exceptions, which didn't know about that until we had the bylaws. But eventually that'll get moved over to, it shouldn't really be in the bylaws. It should be in the zoning ordinance one. So.
I think it's okay that it's in your bylaws.
Yeah.
I think you have the authority
Yes,
to require that as a part of your procedure.
yeah.
It may be nicer that the council said that's a part of the procedure. We do give people the right to that. And so right now that's in your bylaws, and I don't I think it's fine that it's in there, but we've got to make certain that we're following. The one thing I'll also do that I had questioned about is over on page 3, up at the top under 9, it talks about an appeal which is not approved in accordance with this
Oh,
shall not be resubmitted by the Board of Zoning Appeals for a period of 6 months. That gave me a little pause. Let me say this, the city does not, I don't think the city has this. Tom, correct, because I get confused sometimes with what the county has, which I'll have. I mean, there are some places put a 1-year rule down on rezoning applications. In other words, if you do the whole zoning and the council turns you down, you can't run in the next month and reapply. You have to give it a year before you can do a rezoning. I'm not exactly sure what this means here, because I will tell you, I'm not going to allow someone to keep coming back to you on the same issue. Getting legal, there's a term we call res judicata. If something has been decided by a court already, you can't keep challenging it. A rezoning is just asking the council to change the law. Y'all are not making law. You are sitting as a judge to change. This is the facts and here it are. Don't keep coming at us hoping you'll get a different decision. So I'm not even sure how that got in there, because as far as I'm concerned, if somebody comes in and has an appeal, it's done.
So
They're not coming back again.
so 9 should just go away.
But it does say latest revision though.
Huh?
So it does say latest revision. So does that mean that they can change and try to do something different with their next application?
I don't know what latest revision is in reference to.
Okay.
Maybe if the zoning laws were to change in the meantime, and it still doesn't need it, but
Well,
it might be, I don't know.
let me say this, an appeal, this says an appeal.
Okay.
An appeal is you don't like his decision and you're appealing it here. A variance, I guess you could come back in for a variance, but something would need to have changed factually to come back in on a variance, and I don't know how that would happen. I don't see a variance. You can come back again, I mean, that's really more if somebody's like, hey, there's somebody new on the BZA. Maybe they'll give me what I want. But if the facts are the same, I'm going to, if I know about it, and I hope my planning director would go, whoever, and see and say, wait a minute, this has already been adjudicated. And I would tell my BZA, we basically say, it's been adjudicated, we're not hearing this again, particularly if the facts haven't changed. Now, what you could have maybe is a special exception. Somebody comes in for a piece of property, special exception. But again, I would say only if the law has changed. That makes it, oh, I'm likely to get the special exception now. I didn't get it before, but you changed the law. That I can see, if there's been a change in the actual zoning ordinance.
And this would be just for another appeal.
Right, so
So
I know.
not a new
Well,
application for
a
something.
special exception is not an appeal, a variance is not an appeal.
Right.
An appeal is, there's a decision, we don't like it, where it's called an administrative appeal.
So should that line just go away, or should it basically say, you can't keep appealing this, or I think just make that line go away.
Yeah, I wonder, trying to think of any kind of examples where it might.
I think that's something we could go look at to see if anybody else has a statement. What I'm telling you about something's been adjudicated and you don't hear it again, that is a principle of law that you don't actually have to have a rule about. That's a principle of law.
Keep
You
coming back to hear the same thing.
Right, I mean, that's,
Feral cat
if
return.
I mean, that's a defense that you make in court if somebody then sues you again on something like, Judge, here's the decision on this res judicata, it's dead. You can't come back in and try to take another bite at the apple. on something that it's basically, the facts have not changed, nothing's changed, it's done. They had their one chance in front of the BZA to hear it, it's done. So, that's why, because I'm like, this makes it, people think, oh, I did an administrative appeal of Tom's decision, I'm gonna sit here and wait for 6 months and come back in. I'm like, no, 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 no. The BZA will not hear that again. No, they will not. They will not reconsider it. I probably would ask that it be put on there and that you all, we've heard it, it's done, there's no decision making on this, so that we have a record of what we've done. But I would not advise the BZA to basically have another hearing on the exact same thing you've already heard. It's not wrong. They don't have a right to it. Under principles of law, they don't have a right to it. So let's look at that, Tom. You might just want something in there that basically says that, just as a that gives people when they read it.
Yeah.
The notice of that, but I don't want that in there about 6 months. There's no problem with having a 6 months or a year on a rezoning. Once again, that is, hey, can you change the law? Can you change the law?
Yeah.
Can you change the law?
PUD's the only one that has even, it's a rezoning and it has a time limit on it that you can't.
Yeah, it's just PUDs, yeah.
Just PUD's, but.
But I don't know if the county still has it or not, but at one time, if you got turned down for a rezoning, you couldn't do a ask again for a whole year.
Yeah.
Everything else?
Yeah, I've seen it where, you could do it if it was a change, if you want to do a different rezoning, but not,
Oh, you could do a different type of rezoning.
yeah, it's a
application,
different, it's a whole
but you
new
couldn't
application.
ask for the
The
exact
yes,
same
exact same
rezoning.
thing.
You have to wait a whole year.
I've seen that with annexations too.
Yeah,
Annexations
we
where
don't have that. We probably should write that in.
it would be nice.
Anything else? All right, so you'll get that out to us sometime in the very near future.
Yes,
So you'll have a draft.
it won't be next week.
You're about to go out of town, so that's it.
No. I've got planning commission next week. I've got ordinances. We've got the corridor study. We've got the strategic planning committee.
Yeah, we have
We'll give you a
we have
deadline
big
of
meeting
April.
next week. What day is that? Tuesday? When's our meeting?
That's the corridor study.
Corridor study. That's why we have the big TT.
Then we have the council strategic growth
Right.
session all day Wednesday. And then sometime or another, we have to work in an agenda prep meeting. Get the
No, Lisa.
study session agenda out by Friday.
So,
Oh.
we'll get you a draft for you to consider and show all that, and then y'all can talk about it.
I don't think there's any other business, so we will entertain a motion to adjourn.
Make that motion.
You got that motion?
Oh, wait a minute.
We are adjourned.
These days today's hard, because we wound up having, we had airport and a long airport meeting today. We don't normally have it on the same day as your BZA meeting, but we had it, and it was long.
I'll bet.
This is good.
Good, good, I hope so.
Yeah.
Hope you found it useful.
I did, you know.